a question I have for you is there is a quote from James Madison. I can't find the exact language handy, but where he talks about how creating a Bill of Rights would essentially allow for the judiciary, it would be the special province, or they'd be guardians of the Bill of Rights. And I'm just curious, I don't necessarily think that that's a smoking gun that disproves a lot of your arguments, and I don't think it was a super theorized point that Madison was making, but how does that fit into some of your thinking here? And then one other suggestion I might make is that when you're talking about the First Amendment piece of the story, starting on page 15 and going on to page 17, you're really focusing, even though you speak to the religion provisions of the First Amendment, you're really talking about the Establishment Clause. And Vincent Munoz has some great scholarship talking about how he agrees with you, the fact that the word respecting, because in the First Amendment, was really a federalism provision that was meant to only limit the federal government's power both to create established churches, but also to do things to interfere with local churches. I just don't think that necessarily proves your point about the idea that all rights were necessarily meant to be protected through that democratic process. I think possibly engaging with the free exercise clause there more might be a helpful thing for you to do as you're trying to flesh out sort of that relationship between rights and local governance. So just a suggestion.
I wanted to know more, and maybe this is earlier and maybe it's not, what argument for rights absolutism or view you're arguing against, because I found myself trying to imagine what that view was, because I didn't really know. And so, for example, as a kind of critique, you say, the founders thought freedom of speech was a prima facie right, conditional on not conflicting with other legitimate and important interests. So maybe we say compelling instead of important, but that sounded to me like a fairly, consistent articulation with how moderately sophisticated people think we do the First Amendment right now. And so I was like, are you arguing against the kind of the unsophisticated view that maybe a member of the public would have? I just didn't know exactly what you were arguing against. Two, throughout the chapter, you put caring about local institutions in contrast to caring about rights, and I found that really curious because they just didn't seem in conflict to me. It seems entirely possible that the founders cared about local institutions and juries and the like, and also cared about rights, and so to show that they care about the first to me doesn't indicate they don't care about the second. Third, to say that we care about local institutions and not minority rights, again, didn't seem like an either or to me, because if you're imagining a world where people have kind of self-segregated and you have like the Quaker communities over here and you got some Catholics over there and you got some German speakers and they have different interests and different values, you could very much believe that giving a lot of power to small institutions would allow for the protection of minority rights vis-a-vis the entire nation. And fourth, at the end of the chapter, you say you're really critical of judges. Judges often treat matters of moral urgency like a property line dispute, and it just made me feel sad, because and I'm not sure I'm not sure exactly what that means, and I'm not sure that it's true. In that, one, for better or worse, I think we do find sometimes we criticize judges for caring too much about morality and justice and not kind of following the formal rules, and even highly formal people often do so with this great commitment to the importance of kind of moral consistency, or like there's just so many places where morality and values come into legal judgment, and I think judges do it on purpose a lot, either justifiably or unjustifiably. So that sentence just kind of, I needed more. That's all. Thank you.
I was enjoying what I was reading, but I wasn't sure where it was going. And maybe there's a sort of an introduction before chapter 1 where you lay out more of your goals. But I'm not sure the framing with Zubli really works for you. I was thinking more explanation of both what you're trying to say about the difference between how we conceive of rights today and how they were conceived of at the founding, and then what role you see for the government. So Specifically, I think on page 37, you say that your point is to provide a corrective to rights fetishism. And I'm not really clear that you're not any more fetishistic, or that wouldn't be the word you'd use to describe your own position, but I think you're just as interested in rights as the rights fetishists are. You just have I think you have a different take on especially what institutions are best situated to effectuate and enforce rights or give them effect. And then on the flip side of that, you said a few times that the question is, what is the government trying to do? There should be a fact-driven approach. What's appropriate? When is government action excessive? But what I'm missing is your theory of what the purpose of a government is in relation to individual rights. And part of this was, you and I were talking last night, things like concerns with positive rights as opposed to negative freedoms. So what's the role of the government in creating a sphere in which people can actualize? I don't like that word. It's too touchy-feely, but whatever, right? Realize their potential. What's the role for communal rights? You talk a lot about churches and local communities. What's the relationship of the government with respect to that? And I was just wondering, like a lot of, when I was thinking about your writing, I was thinking about Martha Feynman's conception of the vulnerable self and the role of the state in realizing that it's composed of individuals who are, one way or another, going to be vulnerable at some point. I'm wondering if that sort of thinking, also I was thinking about Judith Butler's conception of precarity, and I'm wondering if that sort of thinking is influencing your conception of the role of the state.
On the Madison quote, I do in the paper quote Madison on judges, and I agree the Bill of Rights does empower judges, and so this is not a screed against judicial review. It's to say, what is it that the judge's role is supposed to be? Is the judge's role supposed to be to protect someone from their community, or is the judge's role supposed to be to in some sense work with and preserve the role of certain kinds of local communities? And so it's not about the institution as such. It's about what's actually being protected. The First Amendment story is very Establishment Clause heavy. I think there is a good case to be made for saying more about the Free Exercise Clause. I don't think it's inconsistent in that I think that free exercise of religion presuppose religion being practiced in communities, as opposed to like the classic religious dissenter of today being someone who is like an atheist or something, as opposed to the religious dissenter being someone whose community of co-believers is an outlier and they need their own space to form their own, to follow their own path. So I think it's consistent, but I think I could say more. Christina, what's the argument for rights absolutism that I'm arguing against? This requires a longer conversation, but I do need to get better at saying this quickly. And it's really, I think part of the issue, and again we'll talk about this later, but part of the issue is that the way in which I would describe this argument in this room or to people who are deeply invested in constitutional law, it might be different than I describe it to people who aren't. And the way I would bridge that is to say it's a frame. And the frame is to say that the important question that we are asking when we observe a rights conflict is there a right? And if there's a right, that tells us something about how seriously we should take what the government is doing. The alternative to that being to say that the most important question we have to ask is what is the government doing? That's what we are distinguishing. We're distinguishing instances. What's most important is to distinguish instances in which the government is acting in responsible ways and instances in which it isn't. And that's the important question, as opposed to the important question being, is there a right? As a constitutional matter, one could imagine constitutions where it makes a lot of sense to ask that question, but I don't think we have that constitution, and I don't think we've historically had that constitution. But we could talk about that more. Is local institutions and rights being consistent? I agree. That's what I'm trying to establish, and I'm glad you agree with that. Consistent with minority rights too? Yes, in a way. I think one of the things I want to emphasize is that the presence of a right, and this gets a little bit into this question of fetishism, the presence of a right is not another way of saying the community is a bad actor. It's a way of saying that there's a right at issue, right? And so we should care about that. Some of the folks who should care about that are judges, but others who should care about that are the other people in the person's community, and that's historically one of the ways in which we care about rights is by talking to each other and arriving at democratic outcomes. But I'm sorry you're sad about this question of moral urgency. I think again, we need to talk longer about exactly what I mean there, and you have to sort of fit that into the rest of the context of the book. So I apologize that you only have one chapter, and that one chapter is primarily defensive and not constructive. But what I mean is essentially what I've just said, which is that questions of rights or questions of value disagreements, they are not questions of commas. And so it's not to say that judges don't care about people's rights. It's not to say that judges don't think they're important or don't take their job seriously. It's that there's a conception that ties rights, adjudicating rights conflicts to making declarations about, interpretive declarations about what rights mean. And that, I think, doesn't treat rights with the moral urgency that they deserve. Jeremy, thanks for your questions as well. Zubli will stay in the chapter, but he probably won't start the chapter when all is said and done. And I do think it's not the best, most compelling. Opening, likewise, I don't think I'll use rights fetishism in part because it confuses some of the other metaphors that I use in the book, and so that'll probably get dropped. And you're right that I do care about rights, and that I do think that rights suffer by treating them in what I describe as fetishism. And so I don't think I'm a fetishist about rights, but I do think that I take them seriously. And I'll just take the point about what is the purpose of government. I don't take that to be, I don't have something to say about that at the moment, which is to say, I don't think the book is about that, other than to say the book is about, and the project is about, giving some deference to what governments, to what people think they're forming governments to do. It's not about an ideal conception of what governments do. But we can say more about that.
I really liked the chapter. I think it's terrific. I wanted to ask you to elaborate on something you say on page 37 in connection with the 9th and 10th Amendment discussion, where you talk about the fact that preserving local political institutions meant preserving chattel slavery. And you refer to the fact that you're going to talk more about this in subsequent chapters. And I was very curious generally about your take of the relationship between slavery and the Bill of Rights. I think a fair case can be made for the proposition that the localism that was baked into the Bill of Rights, as you are identifying, was designed in large measure to protect slavery from national institutions. If you look at the convention, the delegates who most consistently propose criminal procedure and jury trial rights are the Southerners. The most plausible reason why the delegates don't incorporate a Bill of Rights into the Constitution, and why Mason's proposal to that effect at the end of the convention was probably a poison pill, is if they had adopted language of the type that Randy quoted from the Virginia Declaration of Rights, they would have immediately had to confront the fact that 3 New England states had already inferred from the statement that all men are born equally free and independent, that there therefore shall be no slavery in our jurisdiction. Massachusetts in the Quock Walker case, New Hampshire, and also Vermont, which is outside the Union but had done so in its constitution. The insertion of that kind of language into the Constitution would have caused innumerable problems for the project of getting the Constitution ratified in the North and the South. When you come to Madison's amendments, I think, I may be alone in this, but I think I could make the case that Madison's amendments in significant part are about strengthening protections for slavery via the vehicle of the different amendments. So the new preamble that Randy talked about puts the protection of property rights right up at the top of the Constitution. He wants to insert 4 new references to private property rights, which until that point had not been mentioned in the Constitution. And again, there are all these jury trial and criminal procedure rights. If you think about how threatened the institution of slavery might be with federal judges of the sort of Cushing, who had decided the Quock Walker case, Jay, Wilson, these are all anti-slavery men at the time. And the idea that they could, say, elaborate a federal common law of crimes or, in general, apply law to disputes arising out of altercations related to slavery was completely threatening. And so it looks like, from that vantage point, that you could go even much further in trying to explain what the role of localism was in the Bill of Rights with reference to slavery, whether or not you agree with all the particular things that I said. And I would love to know what you think about these ideas, since you are writing the book and you have this reference to at least incorporating the relevance of slavery into your discussion. I'm very curious how you see all of this playing out. Maybe it's overstated, maybe not, and I'd love to hear what you think.
Yeah, so I think it'd be really helpful to have an idea set out at the very outset, which is there isn't a single conception of rights at the founding. Rather, there are 2 conceptions of rights. One of the conceptions of rights, which we might call a natural right, is a conception of a regulable liberty interest or property interest. Then there's another conception of rights, which is a sort of common law, more determinate, legalistic conception. And that conception then operates in an anti-majoritarian way in the sense that the legislature can't override it in the interests of the general welfare. But, and here's where your point comes in, those types of rights are actually designed in service of protecting democratic institutions and so on. So, I mean, I think when you say at the very outset of the chapter, there are a set of rights that are generally regulable in the promotion of the general welfare, the reader gets a sort of mistaken idea that all of the things that you're then going to talk about throughout the rest of the chapter are regulable in that way. And I think that's just not true. It's not true that Congress had the ability to pass a licensing regime if it determined that passing a licensing regime would actually serve the public welfare. Rather, that rule operates in a determinate legalistic way, but the range of those rights is very narrow in exactly the way that you say. And so then what's left of rights is a different concept of rights, a concept of natural rights in the regulable way that you've talked about. So hopefully that's a friendly amendment. I mean, I think that's accurate as a description of the way rights discourse is operating at the founding, and I think would help the reader just get a sense of that there are actually 2 different ideas being floated in the founding period.
Chris. Promising not to say anything this one, but great paper. A huge fan of the general project. But a few thoughts. You could talk about state constitutions. So state rights to free press. I think there's 42 of them now that say being responsible for the abuse of that liberty. Which just fits perfectly, I think, with your general picture. I think this actually comes to America from France. So Jefferson and Lafayette are writing their Declaration of the Rights of Man and Citizen, and then Pennsylvania in 1790 is the first American state constitution to include that language, and it spreads almost everywhere. So I don't know. It depends on how much French stuff you want to put in, or just state constitutional stuff. Privilege and Immunities Clause. You got to talk. I mean, clearly that's got to be an element. Carpenter in Bradwell. Privileges are. I'm sorry. Yeah, talk about Article 4 too. I mean, it's probably certainly Corfield has a lot of the same vibe actually. Really, being regulable in the common welfare. But Field is Bardemeyer versus Iowa is definitely. I mean, very fits and Carpenter's argument in Bradwell. He's giving it the same month that he's defending the slaughterhouse monopoly. So he's like in a particularly important place. Will's stuff on proper and Gary Lawson's stuff on proper, I think, the fact that could embed rights within it. Nicholas Quinn Rosencrantz's stuff on faithfully, if that's an anti-discrimination requirement for the president. You can have, something like the First. Why does the First Amendment only talk about Congress? Well, the president already couldn't only prosecute people of one political party or one religion. You already have something like the First Amendment, but from the power perspective, in the requirement that the laws be faithfully executed.
John, I don't know. I don't have a settled view on because I haven't thought about it enough about the degree to which the Bill of Rights was not just consistent with the institution of slavery, but was designed to protect it. That strikes me as I sit here as overstated, but I'd have to think about it and read about it a bit more. And I do, of course, later in the book talk about ways in which slavery and other issues made this a problematic vision for a modern country. Judd, I guess what I'd say is that for the purposes of this exposition, I will take your view as being, the way I'll translate your view is there are some ambiguities that are worth saying something about. I've learned from your work in writing the piece, and I actually made an explicit choice about how deep I should go into the distinction that you develop, and I thought I couldn't do it. But that isn't to say I've done it well here. It's to say you're right to press on there being some more nuance than the chapter allows, and I have to think about exactly how to confront that. And then Chris, I do say a very little bit about state constitutions in the use of ought language in the early constitutions. I could say more. The book really, maybe it shouldn't, but the book largely focuses on federal constitutional rights. There's a number of reasons why I think that makes sense as a matter of framing, but that might not really be adequate to the discussion. So you're right to talk about that. The other references, I think I will take those as matters that I should think about, but the chances that I'm going to get like Nicholas Quinn Rosencrantz's work, or really anything about even John's work on proper into this chapter is very small.
I have a couple of comments. This is more in response to Judd and John. Judd, more briefly, I think the relationship between common law rights and natural rights is a very interesting one. I would have expressed it somewhat differently or added another dimension to it, and that is that natural rights are very abstract. They don't decide a lot of particular cases and controversies just by their very nature and how they're derived from the general nature, from the ways in which we're all alike. That's human nature, the ways, but then there's all these particularities that arise in the course of life. And so applying these abstract principles to particular cases is challenging. And the common law was thought to be a positive law way of discovering and putting into effect what natural rights require. So it is a mechanism, it is a decision mechanism by which you've come up with exactly what are the rules that govern contracts, although the concept of contract, it was governed by the writ system, so it wasn't exactly like what we think of as contracts. Fleshing out what freedom of contract means, if you teach if you teach contracts, it takes 2 semesters or now 1 semester to just get a superficial understanding of what the rules are that might implement freedom of contract. Freedom of contract doesn't get you that far without all of that. And I think the common law was thought to be a positivist law way of cashing out natural rights and stood independently once it was cashed out. John, I think that the pro-slavery reading of the convention that I've heard you articulate so many times needs to be tempered with the sort of evidence that Sean Wilentz has pointed out in his recent book, No Property in Man, which chronicles in great detail the extent to which there was a struggle at the convention between those forces who wanted to establish in the convention, in the Constitution, a ratification of the concept of slavery as property, or as even a justified claim, and the resistance that those efforts met by people who were by delegates who were from the soon-to-be free states, not exactly free states yet, some of which were partially free states, and I think that that should better inform what the outcome of the convention is, rather than some of the debate that happened within the convention. And I would say the same thing about the amendments that produced. You have a story to tell about how Madison might have proposed what he did because it would have been in service of slavery, and you could be right. I don't know what was in his heart or mind, and I don't think there's evidence particularly of what he intended. But that whatever he proposed had to come out of Congress. And Congress had a lot of people there who were very sensitive on the slavery question. And so I would suggest that what actually resulted from the deliberations, regardless of how he proposed, what he proposed, was not, it would be difficult to conclude that it was pro-slavery, given the people who were vetting those amendments would be the same sorts of people who had been vetting the constitutional text scrupulously to prevent it from ratifying the principle of slavery at any rate.
Almost all litigants, civil or criminal, waive their jury trial rights. Almost all exercises of legislative power are via delegation. You need to account for that. I don't think we've ever seen a communitarian theory of waiver or of delegation. That would be very interesting.
I found this very confusing to read without knowing where you stand on Barron versus Baltimore. So if it's like really right, if these rights are only federal rights, not state rights, that supports a lot of what you say, but also changes a little bit the character of what the local institutions and the jury trials look like, because now we have states sort of bound by whatever they want to be bound by. If you think that the rights in the Bill of Rights really reflect sort of like rights that all the states were supposed to respect too, and more or less did respect them, then that changes the character too. But either way, I just found it sort of hard to tell what kind of communitarianism we're talking about without knowing whether you're a barren contrarian or a regular person.
Regular person. Awesome. Mike Ramsey.
I want to press you a little bit more on the 14th Amendment, which a number of people have raised, and maybe that's not fair because I know that's a different chapter we don't have, but it seems kind of important to this chapter too, because if you're if the proposition is something to the effect that we don't have a historical rooted idea of highly individualized rights, because the founding era was more interested in community type rights, as you say here. But isn't there a story could be told? And I'm not necessarily endorsing this because I'm not a 14th Amendment scholar, but isn't there a story to be told that even if what you say about the founding is right, that this shifted in the post-Civil War period, or in the era leading up to the Civil War, and then was constitutionalized after the Civil War, when we discovered that the community sense of rights didn't really work very well because communities couldn't be trusted to protect the rights of minorities, and so there was a shift in the Reconstruction era to a more modern idea of highly individualized rights, and I don't know if that's right or not, and so I just wanted to press a little bit. Can you tell us what you think about that quickly? Where is that chapter going to come out?
Okay, so a theory of alienation. I don't really have a theory of alienation. I don't actually think of as you detected, I don't actually think I don't really think of myself as having a theory of rights. This is a theory of adjudication, and a theory of which institutions are the right ones to think about rights. And so I don't know. I have to think more about whether whether and how alienation factors into that. I don't think it's necessarily, as I sit here, I don't think that it's necessarily something I need to address at any great length. I'm regular on Barron versus Baltimore. I think I've not seen anything that's persuaded me that it's not correct. In fact, I didn't. Well, I'll just leave it at that. And
I just want to say I'm regular on Barron versus Baltimore too, because I'm so irregular on so many other things. I want to be regular about something.
And Mike, on 14th Amendment, I mean, I don't have I don't really have a chapter on the 14th Amendment as such. The chapter that follows this chapter is at least the tentative title is Rights Meets Race, and it is about all the problems that race in particular, but not just race, dissidents, religious dissenters present for this theory of adjudication, and the third chapter is about our failure to reconcile Vision 1 with Vision 2 as the number of categories of rights claimants, dramatically increases, right? So that in the 1960s, we're not just talking about racial minorities or religious dissenters. We have a vastly expanded understanding of freedom of speech, vastly expanding of sexual rights, vastly expanded understanding of women's rights, welfare rights, criminal justice rights, and so forth. And that there are a number of choices we have about how to discipline those rights. We can discipline them by making choices about which ones are really rights and which ones are not really rights, or we can make some choices on the back end about when the government's behaving appropriately and when it isn't. And it's a plea to do the latter of those things and trying to reconcile these kind of different visions of how to think about the right institutions.
I just have a suggestion for you regarding your discussion of the 7th Amendment. So on page 32, in about the middle, you say the 7th Amendment was just another way of saying that the right to a jury trial in federal court should be determined by local political processes. And I'd urge you to take a second look at the material you're using to support that claim. So you're citing Charles Wolfram and Edith Guild Henderson. Neither one of them advances that theory. Both of them are advancing a different understanding of the 7th Amendment, a living constitutionalist perspective, and not one that articulates this proposition. The other source you have is Amar. But Amar has very weak support for this view. So if you go back to Amar, I think you'll find that he just makes this up, and as he sometimes does, and that the argument that he makes, which is based on the Rules of Decision Act, right, just shows that he was completely ignorant of the relevant history, because obviously the parallel would not be the Rules of Decision Act, it would be the Process Act. So the Process Act of 1792 freezes in place local procedures as of 1792. It's not until the Conformity Act, a decade later, that we get a dynamic understanding. And none of this really goes to the original meaning of the clause itself. And I just think it is really radically implausible to think that the 7th Amendment, which says the right to jury trial at common law shall be preserved, means that the right to jury trial shall be neither common nor preserved. It just seems to me like that's a radically implausible meaning. So, and I don't think you need this claim, right? Because even if the conventional understanding of the 7th Amendment is correct, it still puts local juries in charge of substantive decisions. So if the overall theme of the chapter does not require this implausible reading of the 7th Amendment.
I especially liked the sort of where you landed in suggesting that conveying supervision or primary supervision over these questions to judges subject to the entire process to professional and methodological limitations that may not make sense. And I'm hoping that you develop that as the book goes on, and I suspect you do. I'm going to ask a version of a question, I think, that I've heard from a few people, which is what's at stake with the vision that you present as compared to its opponent, as compared to rights fetishism. And in particular, I was struck by, and I actually very strongly agree with, your suggestion that in the Second Amendment context, and the sort of throwaways you talk about it, but I think it's actually right at the heart of this thing. In the Second Amendment context, the heat and light about collective right versus individual right is in some really important respects overblown, because of course you can have a collective right that is enforced at the individual level by individuals and so forth. I would be interested to hear an example or two, if you have any ready at hand, of particular challenges, rights challenges, that would have plausibly been on the radar, anachronistically, of people in this era, that would be resolved differently under the vision or the approach that you suggest, resolved differently by the courts now, and under your vision, and examples of resolutions that would be different under the sort of the rights fetishist approach. That is to say, where would it make a difference? Why isn't it both and rather than this changes how the courts might have been understood to behave?
I have some doubts concerning the way in which you frame your conclusions about the meaning of the conceptions of rights that was embraced by enacting the Bill of Rights. So it seems to me that the structure of your argument goes more or less in this way. By placing rights in a certain institutional structure, those rights have certain legal or institutional consequences, and then those consequences somehow shape the meaning or the conception of rights. Now, this structure is pretty controversial, I think, and it relies on semantic assumptions that maybe you could disclose or display in the chapter. And the fact that legal consequences just by themselves shape the meaning of legal concepts or moral concepts is very difficult. I mean, it has some counterintuitive outcomes. For instance, you have to say that the meaning of rights in the Bill of Rights in the Federal Constitution is different from the meaning of rights in state declarations of rights. Even though basically the rights are maybe the same or very similar. So the idea that the meaning or the conception of rights changes in as much as we change the institutional structure in which those rights are enshrined is, I think, controversial. It's not that there are not legal philosophers who maintain this position, but they are probably very far from your field and interest. For instance, Alf Ross, in a very old paper published in the Harvard Law Review, maintained a thesis very close to your semantic assumption, the idea that rights don't have any meaning except in terms of the legal and institutional consequences that they have. Now, it's not necessary for you to frame your conclusions in this way. There are other ways, for instance, in terms of the goals or the purposes of the Bill of Rights, and not in terms of the conception of rights that the drafters embraced. Probably the conception of rights that they embraced comes from natural law and from the Republican origins of the Constitution, and we don't need to commit ourselves to a different understanding of rights just because there are different political or institutional consequences arising out of the structure in which those rights are placed.
Thanks. Larry, on the Seventh Amendment. You're right that what I articulate, you're right on at least two scores, right? What I articulate is not articulated in Wolfram or Henderson, and is weakly supported by Amar. I agree with that. I also agree that I don't need it, and that it's controversial. I don't agree that it's totally implausible. Maybe we could talk about that more. But I do take the point that talking about something that's highly controversial and not well supported. I don't think there's very good affirmative support about the meaning of the Seventh Amendment that anyone puts forward, right? But you're right. That's a reason not to go all in on one particular controversial theory. So I take that point. Julian. So I will say more about. I mean, a lot of the book is about adopting the methodological limitations of judges. In some ways, that's also a response to Horacio's point. So examples of rights challenges that would have been on the radar then, well, that would be resolved differently under the vision that I I'm not. So I guess the question is, am I so different under the vision I'm criticizing than would have been decided then?
You're tilting against something, and I'm wondering how the alternative vision you're proposing, like in terms of cash out on the ground, how might that have played out?
So I'll just give one example, and maybe I'm not sure if this is fully responsive, but the Supreme Court is fond of saying, for example, in First Amendment cases, that the fact that that freedom of speech in some form is constitutionally protected reflects a constitutional decision to take speech out of the hands of political institutions. I don't think that's right, and that doesn't mean that that every case is wrongly decided. It's to say that doesn't follow. That doesn't necessarily follow logically. I don't mean to argue, Horacio, that the institutional structure changes the content of rights. I do mean to argue that the institutional structure affects how a particular institutional actor should approach their role in respect to rights. So, for example, if a judge is deciding a case about a right that seems to be protective of political institutions and their autonomy, that the way in which that judge decides that case might very well be different than the way in which a political actor decides that case, both of whom are making judgments about constitutionality. That's not a claim about the content of the right. That's a claim about how different institutional actors should approach the right. And so that's the claim I mean to make. And to the degree I am suggesting something about the content of rights in some independent sense, then I don't mean to be making that suggestion.